Welcome to Law Sessions. I am Jennifer Housden. In this session, we will focus on the land law principles of leases and licenses. And in a later full-length lecture, we will consider leasehold covenants. We will start with licenses, and then we will consider leases in depth in this lecture. Now, over the next hour or so, we will see what constitutes a license. We will also see what constitutes a lease, and we will see the determining factors which differentiate a lease from a license. If we consider licenses first then, and what the definition of a license is no more than permission for someone to do some act which would otherwise be unlawful in regard to the land of another person in the absence of that permission. So license simply means permission. What having a license does is that it prevents what would otherwise be a tort, for example, trespass, and therefore having a license means, of course, that you do not break the law. A license, of course, lacks the qualities of an interest in land, and that, of course, as we'll see later on, is one of the main distinctions from a lease. So it does not give you an interest in land, it is not transferable either, and it will not be enforceable against a third party. Now, there are different types of licenses. So, for example, you can have a beer license. So, for example, when one party gives another party permission to do something on his land and there is absolutely no consideration, something you would have learned in contract law. So if there's no consideration or payment between the parties, you are more or less looking at a beer license. You are taken to have given, for example, the postman permission to walk up to your driveway to deliver your mail, or for people to play in a field or to camp. These, of course, are beer licenses because they lack any sort of consideration for the use. Now, in order for you to revoke a beer license, if, for example, you're the landowner, you must allow a reasonable amount of time for the person to leave.